Top of the morning, Dan and Amy. We talked about this George Will column last week, how America became a nation of the woke and wary walking on eggshells. And it's an underappreciated aspect of the last 30 years of the run-up to this identitarian dystopia we're creating for ourselves, as was nicely exemplified by some of the back and forth at yesterday's confirmation hearing, particularly between Ted Cruz and Judge KBJ on the matter of CRT, critical race theory in the school, including the school, Georgetown Day School, on which she is a board member. The piece that George Will wrote is based in part, as he credits in his article, on the essay "The Roots of Wokeness" by Gail Heriot, who's a University of San Diego law school professor. And it focuses on the Civil Rights Act of 1991 and the new Title VII damage remedies that were afforded Americans that led to a substantial spike in the number of harassment charges filed with the Equal Opportunity Commission, and how this really accelerated this oppressors and victims binary that these racial identitarians have now imposed in so much of the nation's schools and other cultural institutions. As you see, the DIE industry, diversity, inclusion, equity industry, that is dominant. That's a significant part, and frankly, a dominant part, because so many people are coward in corporate America, as well as our civic and cultural institutions. For more on all this, we're pleased to be joined by the aforesaid Gail Heriot, professor of law, University of San Diego. Professor Heriot, thanks for joining us. Appreciate it.
Well, thanks for having me on, Dan.
So, so walk us through this Civil Rights Act of 1991, the addendum to existing civil rights statutory law, and how this in part propelled us to where we went for the intervening 30 years and where we are today.
Well, it's interesting because that 1991 Act, for the first time, made money damages for emotional distress and punitive damages available for Title VII violations, for discrimination on the basis of race or sex, et cetera. Up to then, one could only bring an action for an injunction or for lost wages. And what happened is that for harassment causes of action under Title VII, and as you might know, Title VII itself doesn't say a thing about harassment, but courts over the years had decided, plausibly, but it's not actually in the statute, that harassment was also part of Title VII. And because lost wages were pretty much necessary in order to bring an action up to then, there weren't that many actions, and when there were actions, it tended to be very serious harassment. But suddenly, in 1991, when damages for emotional distress and punitive damages became available, the number of harassment cases just skyrocketed. The EEOC was flooded with harassment complaints, and the die was cast, essentially. We started entering a very different world from the world we were into up to then. And, especially on college campuses, but really employers everywhere had to start being really, really nervous about the possibility of being sued for harassment. And, up to then, the definition of harassment was very vague, and it continued to be very vague. And again, back when lost wages were really required, a vague definition was okay. But when emotional distress can be part of your cause of action, then that vague definition starts being a real problem. And even more important, the definition was cumulative. And so little things could add up to a harassment cause of action, just little tiny things. And so employers, especially those on campus because they were already predisposed that way, started telling their employees, don't do anything that can be construed as contributing to a harassment cause of action. And all of that just, it started a process that has taken years to completely unfold. But, you know where we are today, with identity politics being so strong, and employers being so worried about lawsuits. It used to be that practical-minded administrators on college campuses would tell people who complained too much, hey, academic freedom, we want to have free discourse. But once they had to worry about being sued all the time, they had to be very careful, and then instead they sort of changed positions.
And if you're
over the years,
Yeah, and if you're looking for a microaggression, then you're going to find it. And as you say,
oh
this
yeah,
this this definition is so broad, so nebulous that now you're in the business of essentially asserting a right to never be offended, and that's impossible to enforce. But it serves both the ideological interests of the minders, the central planning sort, and it serves potentially the financial interests of people to go along with the minders, those central planning sorts too, doesn't it?
and that's exactly the change that the 1991 Act created by making it suddenly not only ideological but also practical. Avoid litigation. That ends up changing the culture.
Yeah, this is such an underappreciated aspect of this, because people waking up to CRT and die consultants in the K through 12 level. How did we get here? How did we get here? And this is just an underreported part of how we got here. You provided a financial inducement for people who are not ideological to fold in with the most ideological, frankly, Marxists among us. And that's sort of a brain stroke by those cultural Marxists of a bygone era.
Yeah, exactly. And over time that has a real effect upon the culture. And at this point, decades later, we have a huge industry out there that has been created in order to train people not to say things
Yes.
that might contribute to a harassment action. And that whole concept of microaggressions, if you're in the business of training people and you want to make sure that every year, employers call you back to train again, you're going to have to come up with, smaller and smaller things that have to be avoided.
Uh-huh.
And that's where we get microaggressions.
What about social media playing a role in this? Because if your employer sees you tweet or put something on Facebook that they deem might be uncomfortable, they can consider that part of a harassment suit, can't they?
There's no private sphere anymore.
Yeah, I think that's right. That so much of what people do is public now because of social media. Employers can get upset because one of their employees said something on Facebook or tweeted something, and that too can be used as evidence in a lawsuit. And after a while, you don't even need the lawsuits because everybody is so alert to the notion that if they say something that's inappropriate, they can get in trouble. And these days, the trainers tell employees that you shouldn't say things like, "I believe that the person who is most qualified should get the job." They're basically cutting off conservative arguments, and those are arguments that most people believe. And yet, if you say it in the workplace, you can be reprimanded for it.
And so then what is the way back, if there is one? It seems to me that based on your scholarship on the topic, the move to ban critical race theory curricula in schools is misguided. That's not where this needs to be fought out. It needs to be fought out in the courts. Essentially, you need the Supreme Court or lower courts and ultimately the Supreme Court to weigh in on this and basically reverse decisions they've made in the past, including the 1986 decision that held that the EEOC had decided employees do have a right to not be ridiculed or insulted, and that opened these floodgates.
Yeah, if you look back at some of these opinions from the 1980s on harassment, the Supreme Court was shockingly broad in saying that employees do have that right not to be confronted in ways that they don't like, and that can't be. What some people have suggested, and I don't know if this is a good idea, but at least on college campuses where things are particularly bad because you already had the ideology in place even before 1991, and what the 91 Act did is essentially move the practical-minded administrators into the camp of the ideological because now they're trying to avoid litigation. But it's been suggested that schools be required to have First Amendment offices, essentially, an office that enforces academic freedom
Right.
and the First Amendment. The trouble with that is, every time a bureaucracy is created, it's always captured by the left. And so I think that's kind of high risk there. It may be that it won't work out quite the way those who are proposing it
So
are suggesting.
is there something else that could be done? I mean, other than taking on the trial lawyers and this cottage industry that's been created straight away in the courts? I mean, don't you have to get the courts to reverse the posture that they've taken to this point?
I think you're right that we need something a clearer definition of what constitutes harassment, and we need a clearer statement that it has to be very severe treatment and not cumulative, lots of little things sorts of treatment. I mean, that's a crazy idea that lots of the little pins of everyday life can add up to harassment. Ordinary, rude statements. The world is full of rude statements, or statements that are said thoughtlessly. We need a much clearer definition of what constitutes harassment, and it needs to be something that is severe and not simply ordinary life.
Such an important piece, your essay, The Roots of Wokeness. She is Gail Heriot, professor of law at the University of San Diego. Professor Heriot, thanks so much for joining us. Appreciate it.
Thank you.
Thank you. And she joined us on our turnkey.pro answer line.
You're listening to Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Whether you want to travel on-road, off-road, or off the grid, Line X has you covered. When you want the best protection from everything Mother Nature can throw at you, Line X has that covered too. For high-quality bed liners and truck accessories designed to endure the elements and last a lifetime, ask for Line X Spray-On Protective Coatings and travel on. Don't just protect it, Line X it at Line X of Roselle. This is the truck protection for hardworking folks hauling stuff all over Chicago roads and getting beat up in Chicago weather. Line X of Roselle can set you up with spray-on bed liners and accessories for your truck. They also do undercoat and rust proofing on pickup trucks, cars, and light-duty vehicles. You'll have the peace of mind